So hey folks, I'm Molly from the Chagrin Valley Chamber, for those of you who may not know who I am. I also wanted to do a big shout out. We announced our nonprofit of the year, and it is the Bainbridge Area Food Bank. Yes, they have seen triple the need that they typically see. They really need our help. So we are encouraging everyone to join us in making a donation to them. The chamber, aka my daughter, got them a website and has designed it, and it is up and going. So people are now able to donate directly online. It is at BainbridgeAreaFoodForFriends.com. You can also mail in a check, or food items donation is great, because I know that, some people can't afford to donate financially right now. We ask, if you do make a food donation, that your food donation is not expired. It is not a time to clean out your cabinets. It is a time to give food like you would for your own family. So please, and as a thank you to anyone that donates from today's date up until May 31st, we will be taking a full page ad out in the Chagrin Valley Times, and we will be listing every business or person that made a donation during this time. So they will be listed on this ad. So if you make a donation, you will be on the ad as a thank you. And then you will also be in the Chagrin Valley Chamber's newsletter as a thank you as well. So I am going to introduce you to my partner in crime on a podcast that we used to do, but after 100 and something episodes, I retired. But he is continuing, the best podcast ever. So, but he's also an attorney for a local law firm, the Gertsburg Law Offices, which are right in downtown Chagrin Falls. And he's also a friend. I'm going to call you a friend, Alex.
Oh, thanks,
so he's going to talk to you all about law in this new world that we all live in. So Alex, take it away.
Thanks so much, Molly. And thank you, by the way, Molly, for everything you're doing at the Chamber. Everyone on this call sees it and appreciates it. I know I speak for them when I say that. So thank you. So folks, Alex Gertsburg, for those that don't know me, as Molly said, I'm an attorney. I've been practicing business law for almost 20 years now. Our office is on Main Street. I hope that if you're on this call and we've never met, that we can one day. I hope that if you know me, it's not because I've sued you for something, and hopefully it's because we've helped you with something. And I have two partners in crime here. One is Molly, who, by the way, Molly came out of retirement about a week ago to do a podcast reunion show, which you have to listen to if you haven't yet. We interviewed our two of our favorite podcast guests, Bob Hunt and Nancy Santilli, and it was amazing. And they answered a lot of great questions from some of you guys about the school situations during the pandemic, reopening, not reopening, et cetera. So there is, so that's a good thing to listen to. And then my other partner in crime is Catherine Ensign, who is here, who you can see. I asked her to join me because she's way smarter than me. And I give her full license at any point to kick me under the table through Zoom if I say anything stupid. Catherine is a full-time labor and employment attorney and has been for like 30 years, Catherine?
Take the fifth, but yes, right. It's a long time.
I'll tell you, it's between 20 and 30 years. That's all I'm going to say. And so Catherine's my partner at the firm. We're a full-service business law firm, and we have been fielding a lot of questions, as you might imagine, about the coronavirus in general, operating our business from home, and then now, what are we going to do about reopening? So if I can do this without screwing up, I'm going to share my screen with you. Okay. Can somebody just nod? Do you see a?
Yeah.
Okay, good. hopefully you're not seeing also this, us over here. Okay, so, oh geez, here, how do I minimize? Oh, maybe it's this guy. Okay, so talked about who I am. This is our agenda today. Okay, we're going to go over the governor's schedule for reopening businesses. I'm going to talk about how we deal at the firm with questions like this. We deal with all liability questions from the perspective of liability to whom, and these are going to be the 6 groups of potential plaintiffs that you as business owners should always be thinking about when you're considering legal liability. And then we're going to have Q&A. As Molly said, we've taken some of your questions. I've put them into slides. A lot of your questions were already answered in my just general presentation, so you'll see some of your questions earlier. And then those that are left, I've put into later slides. And then we're going to talk about other places where you can go. Talk about drinking from a fire hose. There's so much information out there, and I'm going to help streamline that for you. So here's the schedule, right? As of this last Monday. So starting tomorrow, healthcare providers can start performing surgeries and just services that don't require overnight stays. Dentists and vets can start opening. Then next Monday, it's factories, distribution and construction companies, general office buildings. However, there are requirements that they need to follow before they open, and we're going to talk about that. And then a week later, it's stores, right? Consumer retail and services businesses are permitted to open. Here's what's going to stay closed, unfortunately, right? Schools, restaurants, and bars, although they can keep doing carry-out and delivery. We're still not going to be getting haircuts, at least not legally, right? So we're all going to keep looking like Joe Exotic for a while, and do whatever we do, but do it at home. Older adult daycare services, adult day support, rehab, rooming and boarding houses, camps, and then entertainment. Which if you go to the Ohio attorney or the governor's website, there's a list of entertainment, recreation, and gym sites. There's a lot more categories. You would think entertainment, recreation, and gymnasium is pretty self-descriptive, but it's not. There's a lot of subcategories there. But in general, those folks are still going to have to remain closed. The governor did start assembling a task force specific to restaurants and bars and to beauty shops to help them. Or actually, I take that back. I think it's specific to like hair and beauty salons and stuff like that. And I think they're bringing in other businesses like restaurants and bars, but they are putting a task force together to start reopening those and just get some intel and some opinions from the business community on what's the best way to do that. As I said, whenever a client comes to us and says, I need to form a business, how do I do it without getting sued? Or here's a business idea, or just help me avoid lawsuits, help me avoid investigations, help me limit my liability. Our framework at our firm is to say, okay, who are the plaintiffs here? Who are we worried about suing you? And the reason we start there, it's intuitive, right? I mean, it's number one, it's if you want to figure out what you have to be afraid of, you start by asking who's going to create the claim against you, right? The second thing, though, is it's easier that way because in 20 years of practicing law, folks, it's these 6 groups. It's down to 6. If you can, as a business in general, start thinking about your liability in terms of these 6 groups, then you will address 95+% of all possible claims out there, if not higher. Your employees, competitors, customers, the government, your owners, and your suppliers. 20 years of practicing law, every lawsuit I've been involved in has been with one of those 6 plaintiffs, okay? Once you know who they are, you can start reverse engineering what they can sue you for. and if it's the government, what they can investigate you for. It just makes the whole world of legal liability a lot more palatable, and that's how I'm going to proceed in this presentation to you, okay? So let's go through them. And in each case, what I'm going to do is I'm going to give you things that you ought to be thinking about even regardless of the pandemic, because if you think about those things, you're going to help yourself just be a better, more optimized business in general. The pandemic's going to be over. These things are still going to be around, these liability issues. And second, it is going to help you pandemic-related issues that are nuanced, nothing about what we're doing is a one-size-fits-all situation. As issues come up, ask yourself, who am I without and what can they sue me for? And so part one of each of these 6 questions is going to be in general, and part 2 is going to be pandemic specific, and both will interrelate. So in general, your employees have the highest number of claims against you. They may be the lowest numerical group of plaintiffs. You may have only 2 employees or 20 employees or whatever, but the employment relationship is the one that is the most regulated. There are, as I'm sure most of you know, laws, regulations, rules at the state level, at the federal level, sometimes at the local level. So you can be sued by an employee for a lot more things than you can be sued in general by a customer, who will generally sue you for breach of contract, for premises liability, or for breaching a warranty or something like that. But your employee, boy, they're really protected, so you have the largest number of claims there. What should you do as a general matter to limit your liability to employees? Really good employee handbooks, really good written policies and procedures. You want to talk to your insurance agent about EPLI coverage. That's Employment Practices Liability Insurance. I can tell you right now, a lot of you guys have employees, but no EPLI coverage. After you get off this presentation, call your insurance agent, ask for a quote on EPLI coverage. Good training and a good discipline policy. If you have employees and you don't have an employee handbook and written policies, that's your first, that is going to be that's the first place that a plaintiff's lawyer is going to look to determine how strong their case is, okay? Have an attorney draft a good employee handbook and good policies and procedures. So start there, okay? The next place you're going to go is the protocols for businesses, and this is where we're going to the Wine with DeWine, which I'm guessing a lot of you guys participate in at 2 o'clock every day, right? So with respect to the pandemic, this is the latest protocols that have come out, right? Face coverings are going to be required for employees and recommended for clients and customers. That changed within a few hours. It started on Monday with required face masks for both employees and customers, and then they backed off on that. Now, these are minimum requirements. You guys are as business owners can do higher, more sanitary, more restrictive. You can do more for your business. These are the minimum guidelines that the state of Ohio is requiring as of last Monday. Okay, they want employees to evaluate themselves before coming to work. The employer has to do the same with himself or herself. And so ensuring basically that the employee comes in without symptoms and tells you that they don't have symptoms, that's okay. It's okay for, in this case, to confirm with your employee that they are okay and fit for duty. The governor is telling us so. I wouldn't go into any detail about that with them. There is a, and I've got this coming up in the next slide. If your employee does exhibit symptoms, you're going to send them home, and then you're going to have a conversation between you, them, and a local healthcare provider to do what they're calling contact tracing. So we're going to come back to that in a second. Requirements to maintain good hygiene, like hand washing stations, sanitizing stations, and social distancing requirements. really sanitized workplaces, and then the social distancing inside. Maximum capacity at 50% of fire code. Okay, so yesterday, this is hot off the presses. Okay, yesterday afternoon, John Husted came out with an additional protocol on the use of face masks by employers and employees, and said that we now are going to create exceptions. We gave out these protocols on Monday. We heard from you, the business community, and Ohioans over the last 3 days. Here's some exceptions, right? Employees don't have to wear face masks if there's a rule or law prohibiting it, if it's against industry best practices, and this is going to come out, right? There are going to be discussions about what specific industries have specific best practices that would eliminate face masks. I mean, look, I can speculate here, but just stay tuned. If you are in an industry where a face mask is really a violation of it, then you probably know what I'm talking about. But I'm not going to speculate. I'm just going to report, at least for now. If a face mask is not advisable for health purposes, I'm imagining a scenario where the employee has a problem wearing the face mask. Then that's an exception. If it's a violation of the company's safety policies, and here I'm going to again go back to make sure you've got something in writing of what your safety policy is. And if the employee is sitting alone in an enclosed workspace, they don't have to wear a face mask. And then if there's a practical reason for it, if any of these exceptions apply, put it in writing. Put it in writing. John Husted said that the written justification must be provided upon request. I am guessing that works two ways. One is if the employee requests it, that should be in writing. And two is if the state of Ohio comes to you and says, why do you have these exceptions? That too should be in writing. So most things that I'm going to tell you, and different lawyers have different styles and different comfort levels about this. I generally say write it down. Okay, create good evidence for yourself. I don't like things happening on the side. I don't like things happening on handshake agreements. I do like good documentation. Okay, so more detail is in these three documents, and I'm not going to go into them right now, but these came out, I believe, on Monday as well, or around Monday. If you go here, this is a really important website. And I got to tell you, folks, I don't think I've ever been more proud to be an Ohioan than I have in watching our leadership in Columbus really put the information together and get ahead of this thing as much as they have. Go to this website and you will find these three documents, okay? And when you, if you want to know, right, so here's general office, here's consumer retail and services, and here's manufacturing, distribution, and construction. It's fantastic. They've got a list of what you're required to do and then a list of what's recommended as a best practice. If there's only one thing you walk out of here with today, guys, it is read these three documents or whichever ones are applicable to you. They talk about, applicable social distancing, when you should start considering airflow and ventilation, best ways to sanitize, things like that. So these are going to be really important minimum requirements, but remember, they're just that. They're minimums. You can do better if you want. And remember, too, you're the business owner, right? If you want to, and this, we've gotten questions from this from some of you folks, if you want to do 12 feet apart from each other, if you want one customer in your office at a time, that's your call. It is your business. You can follow that. Okay, so we talked about the employee handbooks. Here's a question that we get periodically. My employee reports symptoms of coronavirus or that they've been exposed to someone with coronavirus. What should I do? Okay, again, the state has given us good guidance here, right? We're going to immediately report the employee or the customer's infections to the local health district. They are then going to take the lead with interviewing them and doing contact tracing, asking them who they've been in contact with, and trying to really get a grip on data, on spread, and on helping them. And that's great because there are HIPAA requirements. There are discrimination laws that apply to how much you as an employer should be getting into their business in the first place. I'm not recommending that any employer, after learning that one of their employees, basically rats them out to the other employees. It is okay.
Shut this stupid Zoom thing off that I'm on.
It is okay to let your other employees know that there has been exposure. I think we've got somebody else here that's not muted here, so can mute themselves if they're not muted. I'd appreciate it.
I took care of that, Alex.
Oh, thanks, Molly.
You're welcome.
So I think it is okay, and I do advise folks to let other employees know that there has been an exposure, and look, be transparent about what steps you've taken to mitigate that risk, to sanitize that area. That's fine, but I'm not okay yet. There may be guidance coming down the road from this, but I've not seen anything that says that an employer can disclose to other employees the private health information of one of those employees just because that employee has contracted the coronavirus. I'm not okay with that, so don't do it. And by creating this regime that says you, employer, contact your local health department when you become aware of an exposure, that's giving you guys cover, right? That's basically saying, yes, you can report this, just don't do it to your employees by name, okay? You should shut down the floor, do deep sanitation, get it professionally cleaned and sanitized if possible, and then work with the local health department to reopen. So here's another question we get quite a bit. You've got employees that are afraid to come back to work, right? What should you do? Well, you as the business owner are going to, oh my, would you? Can you get, young Maya Gertsburg would like to say hi to everybody. All right, she's had a wardrobe change. Thank you, Maya. Can you give me a few minutes? Give me a few minutes, okay? The joys of homeschooling and working are on full display right now for everybody. So look, you have a business to run, okay? You need to fill your seats in that business. Fear by an employee, you want to, okay. You gotta let me do this though, all right? Do you want to, okay, I'm sorry, folks. Here, you can see, why don't you stand over there and then you can be my co-presenter. All right, Maya Gertsburg is gonna co-present with me, folks. All right. All right, well then you gotta be quiet. Okay, now she's shy. Look, if you have the ability to let them work from home, let them work from home. The governor is urging us to allow folks to work from home anyway, so do that, right? But if you need them to come to work and they refuse, find somebody who will do that because you've got to take care of your business. And if that means terminating them, then you terminate them. Honey, you've got to let me do this, sweetie. No, this is important, okay? You can sit here and be quiet, but you've got to let me do this. I mean it, or you got to go. Okay. She wants to know where everybody is. They're behind the screen. I'm sorry, folks. So terminating your employee because they're not fulfilling the job requirements, that is not against the law. Okay. And by the way, that's why there is unemployment. And so they've taken care of the consequences to the employee if that is the case. Now, if there may be exceptions to them getting unemployment if you've provided them with a suitable alternative and they're refusing to take advantage of it, they may not be able to get unemployment. And frankly, I'm not sure how their fear of coming back to work is going to help them. But I'm here to talk about you as the business owner, and what your rights are. And what your rights are the unfettered right to continue your business operations, hire somebody to do the job that you need them to do, period. And if that means that you have to terminate an employee, you can terminate them so long as it's not for a discriminatory reason, so long as it's not against public policy. And in this case, that would be permitted. I know you can't see them, honey, but I got to do this. Can you? They're behind the. Does the ADA apply to COVID-19? The answer is it may. The Americans with Disabilities Act applies where there is and Catherine, you're going to be able to cite and quote the language, but it's where an employee has a material health condition that affects their ability to perform their obligations. Honey, they're behind the computer. I can't explain it. They're in the internet. Where was I, Molly and Catherine? She's looking behind the computer to find you guys. So if the ADA applies, then it means that if they ask for a reasonable accommodation, there's lots of rules, and we could talk all day about the Americans with Disabilities Act, but if they ask for a reasonable accommodation, you may have the obligation to give it to them. One of the reasonable accommodations that they may ask for is something you should be doing anyway right now, which is helping them work from home if your job allows, if their job, their role, their position allows them to work from home. Frankly, that's something that you ought to be doing regardless. And if you look at those three posters that I showed you earlier, that's something that's in all three of them. Work with your employee about working from home. My employee was laid off and is currently receiving unemployment comp. What do I do if they do not want to return to work? So we kind of touched on this earlier. You have the unfettered right to get your business running and to have the seats filled, and the employee not wanting to come to work does not implicate or limit your right to get your business going. If they are sick, that's a different story. If they have been exposed, that's a different story. You should not terminate somebody for that, okay? But if you have a position for them and they can come to work and don't want to come to work, you have the ability to terminate them, okay? And that's the answer to that question as well. Let me circle back on one other thing that I started talking about earlier, and that is like cleanliness and measures that you should take to like sanitize your environment and just protect your employees. As I said, the governor has given you some minimum standards. Those are very good and useful standards, but let me give you a little bit about just risk assessment 101. Perform a risk assessment. Your business is going to be similar to a lot of other businesses out there, but it's also going to be very different from a lot of businesses. And the governor's guidelines are not a one-size-fits-all scenario. Performing a risk assessment means identifying the hazards, walking through your area, identifying where the heavy traffic areas are, like break rooms, places where people congregate. You're going to want to do an individualized plan for your business. Figuring out which of your employees or groups of employees are high risk. The ones that are interfacing with customers are more at risk than the ones that don't. The ones that are elderly, the ones that have asthma. Frankly, this is a situation where you should be thinking about individual groups of employees by risk and seeing if you can protect them specific to their condition if you know about it. So you're identifying the risks, you're assessing the risks. That, in my mind, means asking two questions. How likely is the risk to manifest, and how grave will the results be if they manifest? It's likelihood times gravity equals risk. So analyzing risk in that framework is really important here. Don't just say, I've done everything the governor told me to do, so I'm good to go. No, do the risk assessment. And then there's controlling the risk. Once you've identified it and assessed it, you can avoid risk, and then you can take control measures to the risk. In most cases, I would tell a client, you can often transfer the risk. In this case, it's going to be hard to transfer the risk. You are operating a business during a pandemic. Plaintiffs' lawyers, employees, customers are going to be looking to you to take extra measures now that otherwise you may not have before the pandemic started. So transferring your risk to a cleaning person, to somebody else is going to be difficult. You can try doing it by contract, but at the end of the day, you are the employer, and you should assume that you are the first person there, the first party there, who should be owning the necessarily transferring it or being successful at transferring it. When you read those 3 posters, you're going to see things about high efficiency air filters, increasing ventilation rates in the work environment, putting up barriers between your employees, social distancing, stations to keep soap and hand sanitizer and things like that. So I'm not going to go into that, but all of those are control measures. Okay. And there are others. Okay. Can my employees file for workers' comp for COVID-19? The answer is if they contracted it on the job, then in general, the answer is yeah, they can file for workers' comp. I think that we're going to see a lot of litigation over this question later. I think that in some cases it's going to be it's going to be easier to show that they contracted it on the job than in other cases. Ambulance drivers, folks that just come, in general, regular contact with people that you just know are probably have contracted it. I think that there's going to be a likelihood, or a better likelihood, that they'll be able to demonstrate that they contracted it on the job. In other places, there won't, but I expect that this is going to be the subject of litigation to come. And then, okay, lastly, can I give my employee a different job? The answer is yes, you can. The related question is, do they have to take the job? And the answer there is not necessarily. If it's very different than the job that they applied for, well, look, if they're an at-will employee, then they don't have to work for you, period, at all. The related question is, can they file for unemployment and collect unemployment if you've offered them a different job and they say no? And I think what the unemployment office is going to say is, was this a suitable substitute for your original job? And then there's going to be a conversation that they have with the unemployment office. The employee will have to demonstrate that it was a suitable job that they could have taken in order for them to collect unemployment. Okay, competitors. So remember, there are 6 groups of potential plaintiffs: customers, vendors, employees, shareholders, competitors, and the government. We just talked about employees, and that's probably going to be the longest part of this conversation because, as I said, that's where you're going to have the highest potential number of claims. With competitors, it's as good a time as any, if not a really great time, to look at your confidentiality agreements, look at your internal intellectual property, right? Your trade secrets, things that other people outside of your company don't know about. Look at your non-compete agreements, your non-solicitation agreements, your non-poaching agreements. And if you don't have any of those, now is the time to have a conversation with your lawyer about that. And there's one great reason for that. There are a lot of employees hitting the job market right now. There were a lot of layoffs that just happened, right? That means that you may be hiring some of them, or that means that some of them left your job to go work somewhere else. Did they leave with your confidential information? Are your trade secrets adequately protected when your employees leave? I'm going to tell you something, folks. I don't think that this pandemic, this is me personally, is just going to disappear anytime soon. I think it's going to be a drawn out process. Personally, my best guess is that we are going to be going in and out of quarantines in some industries and in some geographic areas. I think that there are going to be mini outbreaks. There was an article published by The Atlantic about a month ago called How This Will End. And it talks about that, and there's a lot of data there. And I'm not saying this to be a fearmonger. I'm saying this because the flow of employees in and out of business, the high unemployment rate that's happening right now is going to be at a much higher rate than there has been in a long time, if ever. So talk to your lawyer about well-crafted and properly applied confidentiality, non-compete, non-solicitation agreements, okay? And doing an intellectual property audit, determining whether you have potentially infringing parties that are infringing on your intellectual property, like a patent or a copyright or a trademark, or where you may be infringing on somebody else's. Have that conversation with an attorney. It is not a DIY thing. You do not want to be drafting your own confidentiality agreements and non-competes. If you misuse them, misapply them, then you will have a problem enforcing them anywhere within your company. Courts generally don't like those kinds of agreements. They have to be narrowly tailored to advance specific legitimate business interests. So it is important to have them, particularly the confidentiality agreements. It is very easy to misuse them. Will COVID-19 change the way courts enforce non-compete agreements? The answer is I don't know, but if it is true that there's going to be more litigation, which I believe there will be, and that there will be a lot more people hitting the job market, which I think that there will be as well, and which is happening right now. One of the elements to enforce a non-compete agreement is weighing the burden on the employee relative to the burden on the employer to enforce the agreement. Courts don't like to enforce them because courts like employees to be able to get jobs, put food on the table, pay taxes, put their kids through college, right? So it's a very high burden on the employer just to have these things enforced. There probably will be more jurisprudence, more case law, more decisions on those relative burdens when you've got a lot more people being laid off and a lot more people looking for jobs. And a lot of people are going to say, I can't find another job, but I can sure start my own business. And if that business technically violates this non-compete I've got with my former employer, well, now I've got a problem. Now I've got litigation. So the answer is, I don't know if courts will change their enforcement mechanisms, but I do believe that courts will be looking at the issue a lot more and have more opportunity to change those enforcement mechanisms. Okay, customers in general. Okay, your customer relationship and the extent to which your customer can sue you for something is generally governed by two buckets of rules. The first is contract. If you are in the type of business that has a contract with your customers, have an attorney look at it, and if you don't have one, then have an attorney draft one for you. This is another non-DIY thing. You don't want to get this wrong. You've got too much writing in your business on that. The customer contract, the way I always describe it to my clients when they ask me to draft one is, I pretend like I'm the little kid in a sandbox that won't let anybody else play with their toys, right? I draft customer contracts so that it is very difficult for my client, the business, to be sued, right? Or for the customer to sue them and prevail in court. Anybody with $250 can file a lawsuit, but if you've got a well-drafted customer contract, it makes it hard for that contract to get through the litigation process without getting the case dismissed. So really good disclaimers of warranties, really good limitations of liability, attorney fee shifting provisions, dispute resolution provisions. Where can you get sued? What is the process prior to a customer wanting to sue you before they can, for them to approach you to have their dispute resolved? So having a really great customer contract is going to be one of your first lines of defense, pandemic or no pandemic. Then there's the other bucket, which is just consumer sales practices, right? Here we're talking about, there's the governor's guidance on reopening your business, and then there's just the pre-existing consumer rules that you need to follow. You can't misrepresent the quality of your product. You can't lie to your customers. You can't have false advertising. This is a conversation that you'll have with your lawyer when you're asking them to look at your customer agreement. But those are issues that you want to button up now more than ever, because you will have that litigation that's out there, okay? I tell people all the time that whenever you have a giant nationwide event like this, or a global event like this, and particularly where there are economic ramifications, there's two things that you can guarantee are going to happen. Lots of litigation afterwards and lots of legislation afterwards. And that happened in the 2008 economic crisis, when it happened when the dot-com bubble burst. I started my career in 2000, 2001 after the dot-com bubble burst, just working on investment cases, because everybody was suing their broker when their 401k dropped, right? Expect litigation. Use this opportunity now to button up your contracts, okay? How can I further reduce my liability to customers when I reopen my retail business? Look at those posters. Start there, and then do a risk assessment, as we just talked about. Okay, and then I just answered this question as well. Expect more customer litigation. Okay, there's an area of the law called premises liability. Your customers are your invitees. You are inviting them onto your property, and that is the highest standard of care that you're going to have from a premises liability standard. There's invitees, there's licensees, and there's trespassers. Your customers are invitees, and you have the highest obligation of protection towards them than you do to licensees, who are more contractual, or they're there but not as in a customer relationship, or trespassers who aren't supposed to be there in the first place. Okay, with respect to the government, quick and dirty, expect more scrutiny from the government on predatory lending, on compliance with these rules that we went through, the governor's guidance. Expect price gouging attention from the attorney general. We saw, this really hit home locally. There was somebody who had like a bunch of face masks from like a year ago, and then they started selling them for like, $100 or $200 a mask, and the attorney general came down on them like a ton of bricks. Expect to see that. Beyond that, I think the attorney general is going to have their hands full, but the attorney general, their job, among many jobs, is to enforce consumer protection laws. So those customer rules that we just talked about a few minutes ago, if the customer isn't suing you for them, the attorney general can. And the attorney general has very broad powers. They can issue cease and desist letters, and they can get attorney's fees, and it's messy. If you're as a minority business owner, are there any resources to help me comply with the Center for Disease Control and Prevention's COVID-19 guidelines? And the answer is yes. And this is where, the Minority Business Development Agency at the MBDA Business Center has a lot of good information, including funding information there. So if you go there, you'll find additional help. If you are the owner, okay, in general, here's what I want you to do. This is the time to make sure that you've got a good LLC formed. If you have partners, that you've got a shareholder agreement or a partnership agreement. If you're an LLC, it's called an operating agreement. This is the time to make sure that you've got that stuff buttoned up, okay? The state of Ohio has given you a lot of asset protection capabilities, but you got to just jump through a few hoops, and they're not that difficult to jump through. Register with the Secretary of State and properly document your LLC. Don't commingle funds between your personal expenses and assets and your business assets and expenses, and don't commit fraud. And if you can follow those rules, then your personal assets are going to be generally protected. It's also a very good time to start talking to an attorney about your estate plan, either getting it updated or getting it created if you don't have one. There are asset protection mechanisms that you can take through that. And then finally, as I mentioned earlier, insurance. You can do everything right. And you can, and somebody with $250 files a lawsuit, and now you're you're in the litigation casino, and you're in there, you're in there for a while, and you're spending your own money on legal fees, and it can get expensive. If you have a good insurance policy, then you can have those attorney fees paid for. Okay, so have a conversation with your insurance agent and make sure that you are, I say protect yourself to the hilt. Get a cyber policy, get an EPLI policy if you have employees, and get talk to your insurance agent about a statutory policy that protects you for violations of statutes. That can be called a statute. A statute is a law, basically. And this is a good time to be having that conversation with them. Does COVID-19 increase my risk of being sued? And the answer is, the answer is yes. If I'm a plaintiff's lawyer and I'm suing a business and I can find a way to get to the owner, that's called piercing the corporate veil, and I'm going to do it every time because there's another pocket there for me to go after. Okay, so more litigation equals more risk. Button up these issues, and it's as good a time as any to do that. With your suppliers in general, we're talking about well-negotiated vendor agreements, supplier agreements. A lot of small businesses do business with their suppliers on a handshake or on an order form. What we advise them to do is to create a purchasing terms and conditions document and send it to your supplier with your order and have them sign off on it or have them negotiate it. Obviously, if your supplier is like Spectrum, they will not, or some other giant company, they're not even going to look at it. They're going to say, see you later. But a lot of suppliers are business, small businesses just like you are, and they get it, right? So this is where you will want warranties from them. You will want to have remedies spelled out if they breach. You're going to want them to name you as an additional insured on their insurance policy. All of that goes into a purchasing terms and conditions document, which you can have, or if you're not going to have that, just negotiate it directly with your suppliers. What should I do if my supplier can't provide products and services pursuant to our contract? The answer is talk to them and work it out if you can. You're going to look to your contract to see if you've got one with them. You're going to be looking for the provisions that excuse their performance. You're going to be looking for a force majeure clause. That is like an act of God. That would, in many circumstances, cover something like a global pandemic. The governor issued a stay-at-home order that affected everyone. Well, that's called a civil authority provision that may be in their force majeure clause, right? In other words, if I can't do business with my customers, says your vendor contract, then I'm excused from performing. That means that you, as the customer, may be out of luck. Now, there's limitations on how they can do that. If they can find a way around their force majeure event, then they may be obligated to do that. But the short answer is you're going to look at your contract, you're going to see if it excuses their performance, you're going to have a conversation with your supplier and see if you can force them to supply you regardless. And if they are breaching their contract, then you may have a claim against them for damages, which ultimately may result in you finding an alternative supplier and then getting the difference in your cost paid by your original supplier as damages for breach. Okay, next. Here are questions that you guys submitted, and some of these were already answered already, but I'm going to do my best. And Molly, if more have come in, I think I've got about 5 or 6 of these, then I'll turn it to you to ask me them. So here's
I just have one.
You got one more? Okay. Let me go through these because it may have been answered, and then I'll turn it over to you. So one of you asked, I'm offering private appointments for my clients. During the meeting, the door is locked to any other clients. Am I violating the governor's order? I don't think that you are. The governor's order created a minimum standard for operations. You, as the business owner, can elevate that standard. You can let one person into your store at a time. You don't have to open, by the way, at all. And if you do open, it can be on your terms so long as it doesn't go below the government's standards. And remember, the government standards have requirements and then they have recommendations, right? I'm pretty sure that if you wanted to be as restrictive as that, the governor and the law will support you. Let me give you a caveat to everything I just said. Everything that I just said is going to be this, a lot of what I just said is going to be the subject of litigation going forward, right? Nothing that I have said to you is gospel. And if you are not sure about anything that I've said, please have a conversation with your attorney about it, okay? We're doing the best we can to interpret the governor's orders and the prevailing rules and regulations and laws out there, but none of this should be considered specific legal advice for your business. Okay, use it as a conversation starter with your attorney. Next
Alex,
question.
can I just add one more thing?
Sure.
If you are going to lock your door or only see customers or clients by appointment, or even limit the number of customers or clients that you want at your business, I recommend posting that.
Good call. Yeah. I think here transparency is good. Transparency is good. Letting folks know under what terms you are operating is a good idea. Yeah. Thanks, Catherine. Okay. Catherine, your timing is perfect. So as I said, Catherine is much smarter than me. And earlier I was talking to her about this question and decided, I'm just going to let her answer it. So part-time employee was working 20 hours. We reduced them to 10 hours. And now that we are reopening, we're going to increase it again. The employee's asking that they work less so that I can pay them less so that they can get more money from the government, right?
Right. Well, if I could just briefly, what happened is the Ohio Department of Family and Job Services, which administers our unemployment compensation for our state, had a pandemic unemployment assistance program added on. And basically what this program does is it extends benefits to people that were not previously qualified for unemployment, and it also it eliminated the minimum income requirement for eligibility for work for unemployment compensation, and it also increased the weekly payable amount to $600. So what we have now is we have people that were not previously qualified for unemployment getting unemployment. We have employees that weren't making $600 a week now getting $600 a week under unemployment. This particular program ends with the benefit week of July 25th, 20. So any issues you have with your employees saying, I make more on unemployment than I do working for you now at this $600 rate, will end on July 25th. Will it be extended? I do not know, but I highly suspect not, because the unemployment compensation in Ohio is going broke. And they may not have the money to extend these benefits beyond that. So having said that, directly back to the question, individuals that are partially employed is the term we use in the law, but part-time employees or employees that work less than full-time are eligible for unemployment benefits. What happens is if they work part-time or they work limited hours, the earnings is what becomes important. If they make less than 20% of their entitled benefit of $600, then they'll get the whole benefit. If they make more than 20% of their earnings are equal or greater, then the benefits will be recalculated to include those benefits to which they're being paid along with their unemployment. So this particular situation, she's making more on unemployment and doesn't really want to come back. If you want to take her back at the 16 hours a week, she still will be entitled to unemployment benefits. If you want to draw a line in the sand and say, no, you have to come back to 20 hours a week, then you're at the decision point where you're going to decide whether or not you're going to continue on with this employee and whether or not, and then she can also continue on with unemployment.
Can I ask a question to Catherine about that?
Sure, Molly.
Do you have to let your employer know that do you need permission? Or if your hours are reduced, if you're a salary person, your hours are reduced. And not your hours, your pay is reduced.
Okay.
Can you just file, or do you need go through your employer?
You can just file for unemployment.
So an employer doesn't have to give you permission to file.
No, you do not need permission to file.
All right.
I think the next question is also an unemployment question.
Yep. So it's
I have a full-time employee working, and she's being counseled by her friends that she shouldn't work and that she could collect $600 a week. I think what's happening here is her friend is confusing two different programs. We have the Pandemic Unemployment Assistance Program that I just spoke on that extends benefits and is the benefit payable amount until July. The end of July is $600. This particular person is saying she's a single mother and she needs to be home with her child. That actually is a different program. That falls under the Families First Coronavirus Response Act, which is a federal program that extends paid leave due to the coronavirus and also extends it for individuals who find themselves with lack of child care due to a school closing or child care type facility. Now, in order to qualify for these benefits, the employer must have 50 employees or more. And under the federal act, they are permitted to have 2 weeks or 80 hours of paid at their regular paid as a paid leave, or alternatively, after that, they can have 2 weeks, again, the 80 hours at 2/3 pay. And then finally, this child care exception continues paid leave at 2/3 of the regular rate for a period of 10 weeks. Now, they have to be, again, meet qualifications just like they will, or eligibility just like they would under FMLA. They have to have been working for the employer prior to this pandemic. They have to, the reason that they have to be off has to be clearly limited to the lack of child care. So I think what your employee's doing is listening to a couple different programs here, but hopefully that answers your question.
awesome. Thanks so much, Catherine. Okay, we'll keep going. So this next one is one of you asked, I'm an essential business, should we develop a waiver specific to COVID-19 for staff and participants? I think that you're going to have you can do it, but I think you're going to have a hard time enforcing it. I think it's a good idea to be transparent about your efforts to combat COVID-19, right? But having an employee or a customer waive protections that they might have under the law, if you're not following, for example, the state of Ohio's guidance, you're not going to be able to transfer that risk in a written waiver. And I would caution anyone in attempting to do that, particularly with customers, because if that is deemed an unconscionable agreement, then the Ohio Consumer Sales Practices Act will be a violation, and that may subject you to 3 times the damages, plus your attorney's fees. The Attorney General can get involved. So I would be very leery of something like that. But as Catherine said earlier, it may be a good idea to notify everyone of the conditions under which you are operating, letting them know what you've done to social distance, to sanitize, et cetera, how many people can be there. But asking them to sign a waiver is probably not a good idea. I think we talked about this earlier. So an employee's discomfort in coming to work does not create an obligation on you as an employer to really do anything. You've got a business to run. You should try, as the governor has indicated, to allow them to work from home. Try to do that. Everyone should try to do that. But if you can't and you need them on site, you definitely have the ability to put somebody there. And if that means that you can't afford to keep both people on the payroll, then you pay one of them. Somebody else asked, can you deny someone from entering your store if they don't have a mask on? I believe the answer is yes, you can.
Yes.
Yes, you can. Remember, the governor, at one time on Monday at around 2 p.m, you were required to do that. And then by 4:30 in the afternoon, it became a recommendation. So, but you can decide under which conditions you're going to let people into your store. Okay, I think this might be the last one. This is the same slide. What options do we have with employees who refuse to return to the office given their concerns? They're currently working from home. We've answered this question. Try to work with them so that they can work from home. If they cannot come to work, but you need someone on site, you pay the one that you can. We've been getting this question a lot, right? What help other than from the government is out there for transitioning to a remote business platform? Or just in general, getting other help we need. So here's what I'm going to tell you, folks. The first place I would go is Molly Gebler, because she is an amazing connector, and she runs an organization with 500 plus businesses, and a lot of them are there to help each other, right? So being a member of this chamber for us has been huge, and not necessarily connecting us with clients, although it's been that, but for connecting us with folks that can help us as a small business. There are web developers, there are marketing companies, there are IT companies that are members of this chamber, and so working with them is a great resource. Beyond that, we've put a few things on our website we put this out there. We basically got together and just took all the questions that we were being asked that weren't even specific to like the law, and we just started putting them up on our website. So if you go to our website, there's a link for COVID-19 survival guide. There's checklists there. There's resources there. In that survival guide document, there's a list of funding sources that are out there that are more than just the government. We're also giving anyone who needs a notary. We've certified one of our paralegals as an e-notary. And so if anybody needs a document notarized and either cannot or doesn't want to meet face-to-face with a notary, Beth Myers from our office is now a certified e-notary, and we will do that for you for free. We also are giving people free living wills and free estate planning checklists and free healthcare powers of attorney. So go to that website, and there's just a bunch of stuff that we were able to help people out without charge, and that's all there. Let's start with Molly.
I have a question. First of all, I want to mention, you had talked about the fire code, 50%. If you are unaware of your business's fire code, contact the fire marshal, the fire department, get them out there, figure it out. They are going to be on this. They are going to be on this. So check to make sure you know your number. And then we have a question in the audience. What if your job takes you over state lines where there may be a little more lax in rules? Can you refuse to go without penalty?
If you're the employee and your employer asks you to do something that you consider unsafe, then now you're asking me a question from the perspective of the employee, Molly, or am I advising the employer here?
Terry, do you want to, I'm unmuting you. Do you want to?
Yes, this is from the perspective of the employee.
Yeah.
If as an employee, the employer's business demands that there's travel into areas where, Ohio has been exemplary in their safety provisions. But if you are asked by your employer, because I know earlier in this video, we talked about how you can potentially lose your job, or, the employer can enforce certain things. What if they're asking you to go out of state where it might not be safe?
Yeah. Catherine, let's tag team this question. What do you think?
Well, first of all, I don't know that any employers are doing that right now at this time. They may resume travel requirements in the future, but right now I don't think that that's happening. Number two, the first thing I would do is if I had to attend a meeting or meet with a client out of state, is I would explore video conferencing options, Zoom like we're on today. A lot of clients, customers, businesses have become very good at Zoom, team meetings, all other video conferencing platforms. And if that could be accomplished in that manner, I know my own son travels internationally, and he has been doing all of his customer and client meetings via Zoom. So again, it's something to explore, talk to your employer about, see if they would be interested in doing that rather than having you travel.
Excuse me, Catherine, selfishly, yes, thank you. And that's what I've been doing in my real estate a lot, but my husband couldn't be here, and he works in construction. He's a construction superintendent.
Okay.
So Zoom is impossible for him. He's overseeing groups of people. In Ohio, it's great, and he's at a stay at home right now. But, the governor really isn't saying a whole lot about what's going on in Ohio. We're really safe, but David travels extensively. So Zoom isn't an option for him. I'm wondering if he has options.
Yeah, I'm sorry. Well, the governor on May 4th is opening up construction too. So your husband probably will not be under a stay-at-home order effective on Monday.
I didn't think so. Okay.
There's some industries where it's never going to work out, video conferencing. And unfortunately, what I would suggest is if required by his employer to go somewhere, make sure his employer is giving him PPE, protective equipment to take with him, and following whatever sanitation, protection activities that he feels necessary to keep himself safe.
Okay, thank you.
You're welcome.
I have another question from the audience.
Yep.
And you may have touched on this. Are the employers required to work with the employees who have children who will be at home since the schools are closed and remaining closed? What if, with social distancing and effect, the employee cannot find childcare for their children?
As I mentioned, under the FFCRA Act, if you're an employer with 50 or more employees, you are required to extend FMLA leave under those circumstances to individuals who cannot find childcare or the schools are closed. If you're an employer with less than 50, this act does not apply to you. And there's no provisions under the law for employers with less than 50 employees.
I will, let me tag that just to add an add-on. There is, in addition to the legal analysis that you are going to do the public relations analysis too, right? So assuming that you are perfectly okay saying to an employee, hey, I need you to do this. I know you don't want to. And if you don't want to, I'm going to find somebody who will, right? Even if legally you are permitted to do that, you ought to, don't let your analysis stop there. Consider what will happen if that employee then, finds a really aggressive plaintiff's lawyer. And, it is so easy to get to the pleading stage of a lawsuit. Once they start turning their wheels, and then there's the related issue of just talking to other people. We generally advise our clients, find a way to see if you can find a way to make everybody happy. Okay. And if you have to let somebody go, generally what we will advise somebody is, okay, is there going to be severance? And if so, do not pay a dime of severance until they sign a release agreement, right? And in that release agreement, you're going to have confidentiality provisions. You're going to have, a really broad release that says that you didn't do anything wrong. So just consider the extra steps that go beyond just, yeah, I can do this, so I'm fine.
I think we are done. Did you like how I raised my hand, Alex?
I wanted to call on you, but yeah, no, that was good.
Yes. I think we are all done with questions. I have to tell you, I've known Alex for a while, folks, and Alex does something that's very weird when it comes to attorneys. He tries to protect your business and doesn't want you to go to court. Honestly, it's the weirdest thing. I don't understand it, but he makes sure that everything is protected by your business so that you are not going to court. So I can't say enough about the law firm. And I think at the beginning I said that law was boring, and I listened to the whole thing. I mean, you truly, I think you reached, I think, a lot of questions that people have been asking. So thank you so very much. Like I mentioned, I have recorded this. You are going to be able to find this class as well as any of our other virtual classes at cvcc.org. Gertsburglaw.com. Reach out to Alex. If not, for questions, he likes to have virtual Zooms with people all the time. So feel free to reach out to him. Thank you to Catherine. I think a lot of her information was extremely helpful as well. And I'm going to say, if I can, as a business owner, you will never, hopefully, God willing, have this time that you have been given. So I know it's scary and everyone's future is scary, but take this time right now as a gift and get your house in order. Don't ignore what's going on as a business. Be forthcoming. You're on all your websites. The first thing we should see when you go to them is what's going on, what you're doing during this time. Keep in correspondence. People out there want to hear from you guys. They want to see from what you guys are doing. So don't hesitate. Don't just ignore. Freshen up websites. Get your financials in order. I think we all learned that with the PPP, how the people that had it organized, it was fast. The people that didn't have it together, it was tough. Financials in order. If you're a retail, move your register, paint a wall. This is time that truly can be used as a gift to kind of do some things right now, because we are all, as small business owners, we get sucked in. The minute we all go back to this, we're going to get sucked into those day-to-day operations. So use this time. I hate to say as a gift, but as a gift, and kind of get your business in order, and get your website up to date. How many times, I can't tell you how many times we go to websites from our members where the phone number is incorrect, the address is missing something. I mean, these are all things that, you guys have time right now. Asking your customers to write reviews. That's a huge thing. Everyone wants to help small businesses right now. Have them write a review. They're sitting at home online all the time. Send an email to your customers right now. Hey, while you're sitting at home on your computer, write us a review. Little things like that you just don't have time to do. Take advantage of it. And Alex, again, you're awesome. I think this was great. And thank you everybody for joining us. And make it a wonderful whatever day it is, because I have no idea what day it is. So we'll see you guys all later. Thank you.
Thanks, Molly. Stay safe, everyone.